Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Slip it with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. I'm a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Give me 1 second, guys. I'll be right with you. Hello, 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 hello. Welcome back, guys. What's up, everybody that's in the building? Well, Bonjean had to go back and had to redo her appeal. She had to re-enter some stuff that was missing. You know, I know that, she's under a lot of pressure. She has a bunch of different cases. Rkelly's case is not the only case she's dealing with. She is an appeal lawyer. And it so happens to be that she's working on his appeal now. She helped him out with a Chicago case. And now she's doing her job. But unfortunately, she had a death in her family. Her father passed away. May he rest in peace. My condolences to you and your family, Miss Bonjean. Much respect, and I'm sorry for your loss. So she's, I can imagine her mind is, not all there right now. You know what I mean? She's got to deal with all these things. Who knows if she's the only child, and she could be the oldest child and has to deal with all the arrangements and all of these things. Or who knows if she's the only child. You know what I mean? So let me share my window with y'all. I don't know if you guys can see that. Let me see if I should make it a little bit bigger. Should make it a little bit bigger.
Oh, it's coming this way. It's coming this way.
Hold on a second, guys. Let's go here. Let's see, make it.
No, he's coming over here.
Okay, that's good. Okay, so from file number 54, 55, 56, 57, 58, and 59, which I grabbed all these documents. They were $3 each. And this one she pulled out here. Document number 60 had to do with a defective document. The special appendix, the appendix, volumes 1 through 5, documents 54, 55, 56, 57, 58, and 59 that were on behalf of appellant Robert Sylvester Kelly in 22-1481, which is the first one she filed. And then the one that we are looking at now is 22-1982, which is the updated version of the appeal notice and things that she was going to put in. And she entered this today at 9:09 a.m. this morning so she can correct herself. Then she came back with the special appendix on behalf of appellant Robert Sylvester Kelly. Now, this is document 60.
I got a shot. You got a sniper over there.
Which is notice of defective filing. That on April 17th, the special appendix and appendix, volumes 1 through 5, on behalf of the appellant Robert Sylvester Kelly, was submitted in the above referenced case, 22-1982. The document does not comply with the FRAP of the court's local rules for the following reasons. The following reason is defective order, FRAP 32. And she puts down its incorrect caption. The party designations should be appellee and defendant appellant. And appellant's name is missing, aka please see official caption. So she messed up on the the to and from the appellant, who's the U.S.C. versus Rkelly, Robert Sylvester Kelly, who is supposed to be the appellant.
I'm trying to. Airspace is crowded. Airspace is crowded. These motherfuckers be dropping.
And then she also marked in for incorrect.
Come on, look.
Pagination. And it says click here for instructions on how to paginate PDFs, local rule 32.1.
All right, let's get the fuck out of here.
Let's see if I can open a new tab. Okay. Then she also had to mark in other, where she put that the appellant's brief was not filed. So she actually didn't put in the argument, because that is part of the appeal process, is to put in her argument. So she really didn't put in the brief. And she messed up on the names.
Wow, he just broke me. You see? Like I said, Colonel, go back.
And then she says, appellate's brief was due to be filed April 17th of 2023, pursuant to April 14th, 2023 order. So the appellant's brief needs to be filed along with a motion for leave to file out of time. So please, she says, please cure the defects and resubmit the document with the required copies, if necessary, no later than April 20th of 2023. The resubmitted documents, if compliant with FRAP and the local rules, will be deemed timely filed. So failure to cure the defects by the date set forth above will result in the document being stricken. An appellant's failure to cure a defective filing may result in the dismissal of the appeal. Now, inquiries regarding this case may be directed to, and then they give a Manhattan phone number out. Okay. And then the one she submitted before this was like just the example.
I see them on the stairs. Look.
Let me go all the way up.
You still watching the loadout? Oh, sniper.
Okay.
Straight down, straight down. Back there, there's a sniper, straight back.
United States of America appellee versus Robert Sylvester Kelly, also known as Rkelly,
Right there, look.
on appeal from the United States District Court. So the defendant appellant's special appendix, volume 1 of 1. Okay, pages SPA 1 through 204. In the table of context, she's put in the order denying defendant's motion to dismiss and motion to strike. that was dated on May 22nd of 2020. She also put in the memorandum decision and order denying second motion to dismiss the indictment, and that was from October 26th of 2021.
Right here.
She put in the order granting in part and denying in part the government's motion in limine, and that was November 4th of 2021. She also put in the trial transcript excerpts from Judge Donnelly's ruling on the prior bad act evidence. That was from September 14th of 2021. She also put in the memorandum decision and order granting the government's request for a turnover, and that was September 9th of 2022. She also put in the memorandum decision and order regarding restitution. That was November 8th of 2022. She also put in the amended judgment. That was on December 7th of 2022. She also put in the California Health and Safety Code.
Let's push forward. I gotta customize.
She put in the one that's effective from May 26, 2016, as well as the one that was in January 1st of 2018. She also put in the New York Consolidated Law Service for the Public Health Law. That was from June of 1954 law. And this is the pages that she put in. Okay. It talks about the motion to dismiss and so forth, so forth.
Right in front of me.
So this is that. That's one part. So she put in that. Then she had put in the memorandum decision and order.
He's right on top, Don.
And then here is the order.
Yo, Don, take the roof, Don.
On her decision and what, the order that the defendant was charged with racketeering, She talks about the legal standards and that. This was about the request to admit certain evidence. So this was the one about the Jane Does and stuff, the bad acts. So she put in about that.
You seen that? You seen that? He didn't want to jump the wall. Fuck out of here, bro.
Talks about the bribery that happened. They talked about the 2008 trial, his efforts to obtain child pornography. And then here it talks about Jane Doe's number 5's text messages, right? Now, in this order, the government moved to admit text messages that Jane Doe 5 sent to her mother and friends. And then you could look at document number 135 at 18 to 20. And then it says, because the admissibility of these texts turned on trial testimony, I reserve decision for trial. At trial, the text messages were admitted without objection. So the government was able to submit these text messages, and the defense team did not object to those text messages coming in. Then it talks about the employees' text messages and how the government wanted to admit those text messages of 2 of the defendant's employees that recount, among other things, their observations of the defendant's interactions with them and with others. And then it talks about that being in the document 135 at paragraphs 21 to 26 or pages 21 to 26. And then because the admissibility of these texts turned on trial testimony, I reserved decision for trial. At trial, the text messages were admitted without objection. Again, the government put it in and the defense did not object to them. Then defendant's text messages. Now, the government moved to admit the defendant's text messages that his world was huge and had many rules. And that was also submitted in 135, document 135 at page 27. The request was granted, and it was admissible as the statement of a party opponent, which includes part of the Federal Rule Evidence 801D2, and relevant to the enterprise's means and methods, also going with the Federal Rule Evidence of 401, and it was not unduly prejudicial and did not otherwise violate Rule 403. And they also put in an electronic note that the government moved to admit evidence of an electronic note that Jane Doe 5 wrote on a cell phone in August of 2018 containing a list of the defendant's rules. And that request was granted. And that the note was not hearsay, rather it was offered to show the existence of the list and that Jane Doe 5 authored it. It was also relevant. It went to the enterprise's means and methods and the control that the defendant exercised over Jane Doe number 5. Now, as Jane Doe number 5 testified, she wrote the note. Thus, the note was admissible to show that she authored the list. The evidence was not unduly prejudicial, nor did it otherwise raise other Rule 43 concerns. Okay.
Oh, this nigga's right here. I didn't even see him.
Okay, now, evidence about the victim's parents. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. This was also in document 135 at 12 and 14. This request was granted in part and reserved in part for trial. So the defendant wanted to introduce evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with them. And this request was granted in part and reserved in part for trial. So the judge did allow Rkelly to introduce evidence that parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. The request was granted in part and reserved in part for the trial. So Judge Donnelly did grant that they could put in some evidence about the parents. And that at the August 3rd, 2021 hearing, the government represented that it did not intend to call any of the witnesses' parents. And that was spoken at trial. Okay. I believe page 46, I guess trial 46, it says 6 through 12. Now, because a parent could not consent to the charged conduct, questions to victim witnesses about whether their parents consented or permitted the defendant to have sexual contact with them would have been improper under the federal rule of evidence 401. However, questioning with a good faith basis about a coordinated extortion scheme was permissible, including for impeachment. Now, it talks about it more at the footnote. At the footnote number 7. Okay. Now, here at the footnote number 7, it says that at trial, defense counsel asked some of the witnesses questions along these lines. See example, trial 1105 through 1106. Defense counsel asked the witness about her parents' efforts to get the defendant to engage in business endeavors. Okay. So he did ask, and he asked about business endeavors. All right. Let's see, what else was it that I wanted to speak about with this? So let me see. Okay, so now here, Ms. Bonjean is bringing up questions. You know, she's raising this. She's putting this brief in because there's certain things that she wants to talk about at the trial. So this is one of the things that she wants to talk about. That in the proceeding, the judge said, "Good morning, everybody. I know we are going to get the witness in a minute. I am prepared to rule on the motions in limine, and this is part of the proceedings, I am going to adhere to my decision with respect to the videos. I know I've received Mr. Scholar's letter on it. I think that the evidence is relevant. The witnesses have testified to the almost constant videotaping of various sexual encounters, and this is obviously relevant to the videotapes involving the sexual encounters. They're obviously relevant. I think some witnesses have been questioned about whether it's Mr. Kelly who is taping them. And in any event, I think they are relevant. And I adhere to my decision on those videotapes. With respect to the recordings that the government represents, show that the defendant is verbally abusing and threatening someone. I also am going to adhere to my decision that I made before the trial, admitting those recordings. Those recordings they're obviously relevant because they demonstrate the defendant behaving in a way that witnesses have described throughout the trial, that he demanded that they adhere to certain rules and that he directed their activities. The transcript or the evidence that the government has submitted demonstrates precisely that. I would also say that the defense, appropriately so, has challenged witnesses about the extent to which they that their actions were controlled. As recently as yesterday, through Miss Copeland, the defense brought out her opinion that he had never locked anybody in any kind of a room, that he showered people with gifts, never denied anybody food, and that's been a theme of the cross-examination of several of the witnesses. So this testimony that the government proffers, or the evidence that the government proffers is absolutely relevant to that question. And I am admitting that, and you have an exception to that ruling. And then Mr. Canick says an exception to both the court's ruling, Your Honor. And the judge said yes. Mr. Canick said thank you. The judge said, is there anything else before we get to the witnesses? All right, let's get the witness and they will get the jurors. And then the court says the other thing, while we are getting the witnesses, I know both sides submitted a request to charge. We are going through the process of drafting the charge. Okay? So she has an issue with this. She has an issue with this part of the proceedings of the trial. I don't know where she's going with it, but she has an issue with it. Okay? And then this is the memorandum decision and order part for Judge Donnelly's talking about her decision as to why she sentenced him, you know, the way she sentenced him and stuff of that nature. So this is a part of a memorandum and decision, and Bonjean has an issue with this, talking about the Curcio hearing, talking about the pretrial motions, talking about the jury selection, and then the trial, the defendant's herpes diagnosis. Okay? And let's go over that again for those who forgot. Dr. Chris McGrath, the defendant's primary care physician from 1994 until 2019, treated the defendant for herpes. Beginning after June 5th of 2000 and before March 19th of 2007, at the trial transcripts, pages 400 to 405 and page 421, Dr. McGrath advised the defendant to inform his sexual partners that he had herpes and to use a condom during sex, prompting the defendant to acknowledge that he should use a condom when he had sex. That part was spoke about at the trial transcript on 406 and 463. And then Dr. McGrath prescribed Valtrex for the defendant, which his underlining often picked up from the pharmacy. So his peoples were constantly going to go pick that up. And that's spoken about at the trial transcripts on 407 to 409. Okay. Now, she has a problem with the charged crimes and the victims. So, she has an issue with Angela. Angela met the defendant in 1991 when she was 14 or 15 years old through her friend Tiffany. Angela wanted to be a singer and a dancer, and so did Tiffany, who was also in high school, who was an aspiring singer. Now, Tiffany told Angela about the defendant and brought her to his apartment in Chicago, along with two other girls who were also in high school. The defendant and members of his entourage, Bruce Kelly, Demetrius Smith, and Larry Hood, were in the apartment when the girls arrived. The girls followed the defendant into another room, one by one. And this is spoken about at trial. There were already 3 girls in the room when Angela walked in. One girl was removing her clothes, another was standing there, and the third was taking off her shirt. The defendant, Angela, was to climb on top of him and to straddle and ride him. Angela was a little startled, but did as the defendant asked. She asked if the defendant had protection. He did not. So she got a condom, put it on him, and they had sexual intercourse in front of 3 girls. In front of the 3 girls that were there. The defendant had intercourse with at least one other girl in the room and engaged in sexual contact with all of them. When Angela left the room, Demetrius Smith, Bruce Kelly, and Larry Hood were still in the apartment. For the next few years, Angela saw the defendant with Tiffany and a different assortment of young ladies on a regular basis. At some point in 1991, the defendant told her to choose between going to school or a singing career. She stopped going to school, and she, Tiffany, and another girl formed a group that the defendant called Second Chapter. From the time she was 15 until she was 17, Angela had sexual intercourse with the defendant at his apartment, at his recording studio in Chicago, and while they were on the road. She did not want to have sex with him, but the defendant told her and other girls that they had to pay their dues. And that's Angela's story. For those who don't remember, for those who don't know, for those who are out here lying on her because they don't know shit, need to stop. Give me 1 second, guys. My phone going off. Yeah. Thank you for the super sticker, purple. Thank you, mama. Hey, what's up, Miss Jones in the building on Facebook? What's up, my lady? Okay, let's get back to the paperwork. Where was I at?
Yo, I got raped over here.
No, that's not it. Sorry, wrong one. I think we're here. Nope.
I dropped one of them, though. Why am I by myself? Niggas is fucking trying to get me, bro. The whole fucking team right there.
Oh, wait. Where the hell?
Yo, they're in the double.
Oh, wait.
They're in the double.
Wrong side, guys. Wrong side. Okay, here we go. All right. Now, then she's complaining about Aaliyah and count 1, the racketeering act, right? So she wants to bring that up in the appeal.
I'm going upstairs or what?
Okay, wait, hold on. Right, okay. She wants to bring up the Aaliyah count 1 racketeering act. Okay. Now, with this situation, it's about the bribery. It really has nothing to do with Rkelly marrying Aaliyah or engaging in sexual contact with Aaliyah. This count is part of the predicate act under the racketeering laws, right? So if you violate any one of these predicate acts, gambling, laundering, bribery, murder, things of this nature, right? You have a conspiracy to commit these acts. Conspiracy means that more than one person, a group, a corporation, an entity, a group of people who conspire to commit a crime. Okay? Oh, that's my daughter. Hold on, guys. All right, I forgot my daughter's a teenager and she wants to hang out with her friends. She asked me permission. She wants to go hang out in the park with her friends. She just got out of one of her clubs, a cosmetology little course she took real quick. So, okay, let's get back to it. Okay.
Mom, it's starting to get bad for me.
Uh-oh, here goes my son. Hold on, guys. All right, sorry guys, it's after school time. My son is doing good. My son is doing absolutely wonderful. He's enjoying it, you know. He's complaining now that he's got a lot of books now, you know, but he feels like a real student, you know. Him being in that District 75 was not working out for him, you know. It was making him more discombobulated, I think. I think him being in the inclusion with other students is working out very, very, very well for him. And I'm very proud of him. Very proud of my son. All right, guys, so let's get back to this. Yeah, he's doing really good, honey. He's doing really good. Matter of fact, you know what? I didn't even get to say what's up to anybody in the building. I didn't today. I just went straight in, go for the gusto, and do the work. Shout out to the truth, who's working, damn it. It's all right, mama, I love you. T-Bam, what's up, baby? Rocking with the truth. What's up, sis? Cherie, what's up, lady? Hey, Sonia. I haven't seen you in a minute, Miss Lady. How are you? All right. Shorty, what's up? Swoop like me. What's up? How are you? Welcome. Swoop like me, welcome. Bev, what's up, lady? Everybody, welcome Swoop like me in the chat. Thank you for subscribing. Hey, Purple, what's up, sis? Nexie, I love you, mama. What's up, baby? Who else is in the building? A2L. What's up, A2L? How are you, honey? K-Love. Shout out to you, sis. Good afternoon. Ty. My baby girl. My sister. Ty. What you doing, Ty? I hope you're being a good girl, Ty. Samara, what's up, mama? What's up? Jacqueline, what's up, Jacqueline? Cat, girl, I'm gonna call you later. I gotta remember to call you later. I know you hit me up and I forgot to call you back. K-Love, what's up?
This nigga sitting in the corner, you fucking bitch ass.
Otra vez, tears. What's up, lady? All right, working in those bushes. Keep working, mama. Working and listening.
Yo, he was sitting in the corner, this bitch ass.
Right, how she missed that much? That's crazy, right? It's like I said, Bendito, she's going through it. You know what I'm saying? I really hope these groupies don't pull up on Boho because they mad about this appeal. I mean, why they gonna be mad? I mean, the lady, thank God somebody on that side decided to give her a warning and be like, listen, lady, girl, you done messed up, lady. You done messed up. We need you to fix this before this judge decides to throw it out. Because that's exactly what was going to happen. The judge was going to go, what the fuck? Girl, no, start over. Come again. You know what I mean? And these processes cost a lot of money. This isn't cheap. So, she's lucky to have someone on her side that's reading these documents and paying attention to shit. You know what I mean? West Coast, what's up, my lady? But I thought this was she do. How she mess up like that? Like I said, she's got a lot on her mind, this poor lady. Wings, what's up, Wings? Hi, baby. I miss you, lady. How are you, sweetie? Candy! What's up, my girl, Candy? The infamous Candy. She's known on these streets. You too, Cat. Why they messing with you, Cat? Why they keep messing with you, Cat? Cat's going in people's comment sections and they not liking what she has to say. That's just like my girl, Take Rkelly. They be yelling at her. They be yelling at her. Next he says, I bet Jane Doe number 5's mom is probably pooping bricks right now. Amos, ¿cómo estás? How are you, brother? What's up? Yeah, the fake made up text, of course. They're all crazy over there. Yeah. No. That doesn't mean they gave him permission to screw their child. Stupid. Right. LaShawn, what's up, sis? How you doing, mama? My day is going great so far. I just finished taking care of the old lady. Now I'm here with you guys. And then I'm going to deal with dinner in a few. So that's why I'm not going to make this live long. All right. I just wanted to give you guys just a gist of what she's going to be bringing up in her brief. So when she does the correction and she comes back with the right paperwork, then we'll read her argument. All right. Because that's what I'm looking for is her argument. All right. That's what we're looking for, her argument. You getting ready for work, LaShawn? Okay, baby. You have a great day, sweetheart.
I didn't know there was
yeah, grasping at straws because he was broke ass, sorry ass. Okay. Okay. Shorty says, sounds like she's going after Anne Donnelly's ruling. Yes. Yes. You're absolutely correct. She's going after her rulings. She's going after her rulings. She's complaining about her rulings. Donnelly is gonna, well, Judge Donnelly has nothing to do with the appeal court. Judge Donnelly has nothing to do with it. It's just his team, the judges, and that's it. If the prosecutors must be brought in, then the prosecutors will be brought in and take oral arguments. That's only if the appeal goes to a hearing. Because right now what's going to happen is the judge is going to go over it. She's going to read it. They're either going to deny it or they're going to grant it, or the judges are going to say, I need to hear more. So I want the prosecutors and the defense to come back to have oral arguments. So once they do the oral arguments, that's another chance of that the prosecutors and the defense can debate in front of the 3 judges or 5 judges. I don't remember how many it is exactly. What's up, Mom Life? How you doing, baby? Okay, baby, you at the gym? Work out, baby. Work them legs. Work them legs. Herpes, herpes, herpes. Hey, Aisha, what's up, ma? Right, tears denied. Womp womp. And Levi. Don't worry, Levi. I got you, Levi. I got you, Levi. I'm gonna rebut and ask whatever questions you had for me the other day. So I'm still trying to figure out what you're trying to ask me exactly, because you talk in circles and riddles and shit. But I'm a smart girl. I'm gonna get to it. Okay, I'm gonna really sit down and play it on my live, and I'm gonna answer your questions at the same time. All right. Don't strike me, brother. All right. Purple, once again, thank you, my love. Fat boy, what's up, fat boy? ¿Cómo está? ¿Cómo estás, mi amor? And Miss Parks out there, Miss Wifey. How you doing, Miss Wifey? Out there on Facebook. What's up, lady? All right. Tune! What's up, my goon? What's up? Les Smith, what's up, my lady? How are you, baby? All right. Yes, please. Don't forget, guys, hit that like button. Yes, y'all. Yes. Hey, Charlotte, how are you, honey? What's up, lady? I know everybody's working and shit. I don't think they understand it. No, they don't. A lot of them don't, but Wifey. Now she's on her food channel. Honey bunny, what's up, my honey? Hi, Nana. Les Smith said, you mean she screwed it up from jump? In and out at my 8 to 5. Okay, sweetie. All right. Pita, what's up, my lady? How you doing, baby? How are you, sweetie? Hope you guys are having a good day. Everyone that's out there. Just V, my lady. How are you, loca? What's up, cutie pie? All right. Okay, everybody's saying hello to everyone. Yes, please hit the like button. Mira que di que este dices, Ty, can I get your autograph? Ty, you better start getting autographs, giving out them autographs, okay? Everyone, please hit the like button. Stop being ugly and stupid. Thank you. Please do. Yes, we is in the paperwork. And thank you, Mama Purple Purple, as always. Love you, baby. My biggest supporter. I love you. Now, okay, so let's get back to this paperwork, y'all. All right, so as I said, she's complaining about the Racketeering Act 1 that has to do with bribery. And it talks about Aaliyah. It has nothing to do with the marriage, but the marriage is part of it because that was part of the grand scheme. The grand scheme was to get Aaliyah to marry Rkelly so that he wouldn't go to jail in case if she decided to have the baby instead of having an abortion. He can't lock her up. He can't get locked up because they're married. But the problem is that she was underage and the parents didn't give her permission to marry him. Now, had the parents given her permission to marry him, that would have been another situation. Rkelly would not have come back to bite him in his ass eventually. Because that's basically what happened. All right. So, and then she's going to complain also about Stephanie, count 1 with Racketeering Act 2. Okay. Then she's also complaining about Addie. Now, remember, Addie is the girl, I believe. I don't know if it was Stephanie or Addie. Let me see. Was it Addie? Or was it Stephanie?
What are we doing?
No, I think it was. No, it was Addie, right? Or was it Stephanie? Who was the girl? Wait, let me see. Was it Stephanie?
Jump in the water. Oh, behind me. Look at this shit. Come on, bro.
No, I think it was Addie. It was Addie who was at Miami, right? The Miami concert on September 2nd of 1994. So Addie was the one that was the first girl he statutory raped, because that's basically what he did. He raped her right then and there, right after he married Aaliyah. Like, go figure that. And then there was Kate. She's complaining about Kate and Sonia and Alexis and Louis. All the bad acts that were entered in here. She's also complaining about Alex and Geronda, which was count 1 Racketeering Acts 5, 6, and 7. So she's trying to throw all this out. Anna, and then about Anna. You know, and then we have Jane. Now, Jane has Racketeering Acts 8, 9, 10, and 11. Counts 2, 3, 4, and 5. That's why, this is why, right here, this is why everybody is in an uproar about Azriel. Because Azriel has acts 8, 9, 10, and 11, counts 2, 3, 4, and 5. So they're like, oh my God, she's got most of the charges. Oh my God. Because a lot of the other girls, it's just, let's see.
Dad, look, I've been watching One Piece on my phone, right? The battle against Katakuri and Luffy is
Geronda, count 1, racketeering acts 5, 6, and 7. She's only got 3. 1 count, 3 acts. Okay? 1 count, racketeering acts 5, 6, and 7. 3 different things, 3 predicate acts under the racketeering law. Okay? And then the other one was Stephanie, I think it was, right? Then Sonia, which her count was thrown out completely. Sonia's count 1, racketeering act 3 and 4 was thrown out. She only had acts 3 and 4. No extra count. Then when you look at Stephanie only has count 1 and racketeering act 2. That's it. That's it. And then there's Aaliyah with just the 1 act. So this is why the focus on Azriel is very strong. They think that if they get rid of Azriel, Az, who has the most counts here, Jane's counts 1 count, count 2, it's count 1, count 2, count 3, count 4, and count 5. 5 counts. 4 acts. She does have the most charges.
Yo, I shot that bitch.
Okay?
See, as soon as we fucking move, we die.
So that's why they're focusing on her. They think that if they get her thrown out, that will give a chance for Rkelly to have less time. Maybe he might get a new trial, let's just say. And if he does and they decide to impeach Azriel's testimony and all her counts and acquit him of that and decide to charge him with the other girls, then maybe instead of him getting sentenced to 30 years, he might get sentenced to 20. Now that'll be easier for the supporters to digest, as opposed to Rkelly having 30 years for these charges. That's just my opinion. It's just my opinion. So Jane has most of these charges. And then there's Faith. Faith has count 1 of the racketeering acts. She's got 12, 13, and 14. Counts 6, 7, 8, and 9. So she's got 4 counts, 3 predicate acts. So these 2 young ladies have the most counts as into the racketeering charges. That's your son. Okay? So Bonjean is complaining about all this stuff. Now, let's take a look real quick as to what was submitted as evidence, and it says other evidence, okay? The jury heard additional testimony and saw other evidence that corroborated the victim's testimonies, including from the defendant's associates and employees. Now, in addition, the government introduced evidence from the defendant's storage facility, including an altered birth certificate for Geronda that changed her birth date from 1993 to 1990. Now, pay attention. This evidence I'm talking about right now is what was found in Rkelly's storage facility. Okay? So if y'all want to know what was in the storage facility, here you go. It had an altered birth certificate for Geronda. It had multiple false confession letters from the victims and employees, and recordings, including an audio recording in which the defendant, accompanied by George Kelly, accused Kayla, Jane Doe number 20, of stealing one of the defendant's watches. Government's Exhibit 485. The defendant said, "You know how I am with cameras," and claimed to have cameras everywhere, including in his studio garage and van. And Kayla admitted that she took a watch, a t-shirt, earrings, and a porno tape, prompting the defendant to say the following: "There's only one way you're gonna get rid of this. For me to trust your ass again, you're gonna do the fuck I tell you to do. When you made the fucking tape for me and I looked at that shit, you was hiding your fucking face all over that shit because you didn't want to be seen. And you ain't gonna hide your fucking face on me. You're gonna do what the fuck I tell you to do. And you're gonna do it fucking right. Then I'm gonna gain my fucking trust back with your ass. If I even detect you trying to hide on that shit, I'm gonna blow this shit the fuck up. Do you hear this shit? I'm telling you, I fucking raised your ass. I raised you. You better not ever in my motherfucking life take from me again, or I will be in Florida and something will happen to you." Now, we all know that that's what happened to Lisa Van Allen. First of all, the last time you was with Lisa Van Allen was in 2007. Why are you holding on to tapes and audio from 2007 and you're in 2021, my man? He held all these tapes and audios and stuff as trophies and collateral and exploitation of young women and minors. Period. Then the defendant ordered Kayla to the garage and to stay there until he told her she could come out. Then he added, "When I come and get you, you better fucking like you're supposed. You better be fucking like you're supposed to be fucking." Wait, I'm sorry. "When I come and get you, you better be fucking like you're supposed to fucking be. You're not going to tape until I tell you. When I tell you, I don't give a fuck
You gotta focus, man.
if you're coming out of your sleep. You better be fucking ready. Do you understand? You make no fucking calls except to the studio or me. Now, this was on audio that he held for over 20 years. Like, what? And you're not guilty of abuse? Really? You're not guilty of exploitation of these girls? Really? Interesting. Now, here talks about the defense case. Okay? So there's an issue with the defense case. All right? And the defense called 5 witnesses at trial. Danny, an aspiring rapper who worked with the defendant for approximately 15 years. Larry Hood, the defendant's childhood friend and former Chicago police officer, was on the defendant's security team.
This is why we fuck up, because we're not nice.
Jeffrey Meeks, who worked for the defendant for more than 10 years, including as a runner. John Holder, the defendant's accountant from 2018 to 2019 for about a year. And Julius Darrington, a music consultant who worked with the defendant for about 4 years. Now, the defense witnesses testified that they never saw the defendant strike a woman, lock a woman in a room, or prevent a woman from eating or using the bathroom. Some of them testified that the defendant permitted them to be around his female guests and that the female guests were not required to look away or look at a wall. Hood, who regularly accompanied the defendant from the gym to White Castle or McDonald's and to the studio, did not hand out the defendant's phone number or recruit women for the defendant. He did not see the defendant with underage woman during his time as a defendant's security guard. And then Meeks, who checked IDs at the front desk of the defendant's studio, did not recall any women being underage, although he was not sure if he inspected every ID, thoroughly. Now, Ramanaran, I can't even say his last name.
Oh, get a shot from behind.
Ramanaran,
Where the fuck am I?
that guy Danny, never saw the defendant verbally abuse a woman. Holder never saw the defendant abuse any of his girlfriends. And that was Rkelly's defense. That's it. That's all. Okay? Okay. Now, as the verdict came down on September 27th of 2021, the jury convicted the defendant of all counts. The jury found that the government had proved all predicate racketeering acts. Again, the government had proved all the predicate racketeering acts, except racketeering acts 3 and 4 that were relating to Sonia. Okay? Now, in this discussion, there was a motion for an acquittal. The defendant makes a Rule 29 challenge to the sufficiency of the evidence for every count of the indictment. the racketeering count, and each predicate act, and all 8 Mann Act counts. These challenges are unavailing. A court evaluating a Rule 29C motion views the evidence in the light most favorable to the prosecution and will uphold the jury's verdict if it determines that any rational tier of fact could have found the essential elements of the crime beyond a reasonable doubt. And then it cites about a certain case. And in this case, they talk about to succeed any Rule 29 motion must demonstrate that, viewing the evidence in the light most favorable to the government, no rational tier could have found the essential elements of the crime charge beyond a reasonable doubt. Now, viewing the evidence in the light most favorable to the prosecution means drawing all inferences in the government's favor and deferring to the jury's assessments of the witness's credibility. A court must consider the government's case in its totality rather than in its parts, and that the sufficiency test may be satisfied by circumstantial evidence alone. Again, that the sufficiency test may be satisfied by circumstantial evidence alone. Thus, a defendant challenging the sufficiency of the evidence bears a heavy burden, and the defendant has not sustained his burden. And then it goes through explaining the racketeering, okay? And again, it says that the racketeering, which is the RICO statute, makes it unlawful for any person employed by or associated with any enterprise whose activities affect interstate or foreign commerce to conduct or participate in the conduct of such enterprises' affairs through a pattern of racketeering activities. And that's under the 18 U.S.C. statute of 1962C, that the statute further defines the enterprise to include any group of individuals associated, in fact, although not a legal entity, under the 18 U.S.C. 1961-4, as the Supreme Court has observed, the enumeration of included enterprises is obviously broad, and the term any ensures that the definition has a wide reach. Okay? So, there goes that. Then it talks about the Supreme Court has consistently rejected arguments aimed at narrowing the statute's broad reach. Thus, an enterprise need not have a hierarchical structure or a chain of command. Again, thus, an enterprise need not means it doesn't need to, okay, have a hierarchical structure, okay, like the octopus. It doesn't have to have that. There's no need to have this hierarchy structure or a chain of command. Decisions may be made on an ad hoc basis and by any number of methods, by majority vote, conscientious, a show of strength, etc. And this has to do with the Boyle. Okay, another case where further members of the group need not have fixed roles. He could have been Don Russell, who didn't have a role in being really involved and employed by Rkelly. He didn't need to have a fixed role to be part of the enterprise. Not at all. And the group need not have a name like the enterprise.
I'm getting a shot from both sides. Hold on.
Regular meetings, dues, established rules and regulations, disciplinary procedures, or introduction or initiation ceremonies. This doesn't have to be. This is not necessary in order to figure out what an enterprise is or to have the make of an enterprise. These things are not necessary. They're not. Okay? Now, while the group must function as a continuing unit and remain in existence long enough to pursue a course of conduct. So when Rkelly's out there doing his concerts and the security team and his entourage are writing down a bunch of numbers on a bunch of papers, ripping them up, preparing them so that when they go out into the crowd, they just handing out his number. Handing out his number. Here. Like I said, Rkelly would say, yo, you see that girl in the third row with the red hair? Yeah, give him my number. He walks over to the side, says whatever to security, comes back and continues his performance. This is what he do. Or if not, he'll give a wink or a head nod and things of this nature. Okay? That is what a group, while the group must function as a continuing unit, like they did, driving the girls, making the appointments, doing this, doing that, getting them food and all this and that, being a runner. You're part of the enterprise while you're in a group that must function as a continuing unit to make sure you keep bringing the girls in, and remain in existence from way back when in 1991 all the way to 2019 till your ass got locked up. You are a continuing your unit, and you have remained in existence long enough to pursue a course of conduct of illegal sexual activity. Nothing in RICO exempts an enterprise whose associates engage in spurts of activity punctuated by periods of quiescence. Now, Boyle also makes clear that the RICO statute is not limited to groups whose crimes are sophisticated, diverse, complex, or unique. For an example, like a bank robbery. Okay? It ain't gotta be. For example, a group that does nothing but engage in extortion through old-fashioned, unsophisticated, and brutal means may fall squarely within the statute's reach. So a form of extortion is a way. Against this backdrop, I address the defendant's argument that the government did not establish the existence of an enterprise, that the enterprise's activities affected interstate or foreign commerce, or a pattern of racketeering activity. So the enterprise, in challenging the existence of the enterprise, the defendant does not appear to contest the evidence that he was at the top of an organization and that he had groups of employees and an inner circle who worked to promote the defendant's music brand and to tend to his personal needs. Now, relying on a First Capital Assessment Management, Inc. versus Satinwood case that happened in the Second Circuit in 2004, they put down the law and said that the defendant insists that the government did not prove a RICO enterprise. In this case, in the First Capital Assessment Management case versus Satinwood, the defendant insisted that the government did not prove an enterprise. Now, in Satinwood, the Second Circuit stated that for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. And in Rkelly's case, they did that. Okay, and then it's citing another case law, two case laws, or three. One, two. Okay, two case laws. And in citing this language, the defendant contends that the government had to establish that the defendant, his employees, and entourage came together with the common purpose of recruiting women and girls to engage in illegal sexual activity and produce pornography, not merely the broader purpose of promoting the defendant's music or brand.
How many times will he go to this damn port?
And this is explained in Rkelly's document number 273-1 at 12 and 14.
There's always money there. First time name.
So that is that, guys. Okay, then it talks and explains about interstate commerce and that how Rkelly is also disputing this interstate commerce. The defendant also disputes the interstate commerce aspect of the government's case. To satisfy the RICO statute's interstate commerce element, the government must prove that the enterprise engaged in interstate or foreign commerce or that its activities affected interstate or foreign commerce. However, only a minimal effect on interstate commerce needs to be proven. So any conduct having even a de minimis effect on interstate commerce suffices. Transporting goods across state lines is a classic example of engaging in interstate commerce. Use of an instrumentality of commerce, such as a telephone line, is also generally viewed as an activity that affects interstate commerce. And that at trial, the government established that members of the enterprise arranged travel across states and internationally for the defendant, other members of the enterprise, and the defendant's victims. And they speak about that in the trial transcripts. And it states the pages. And as explained in more detail below, multiple predicate acts allege that the enterprise members arranged the interstate transportation of the defendant's victims in violation of the Mann Act. That evidence which the jury credited is sufficient to establish an effect of
Edny,
interstate
how
commerce.
the fuck did he shoot me? I went up the roof and I jumped down. Where the fuck did he come from?
Okay.
Oh
And then it cites a case, United States versus Saracone, that happened in the 11th Circuit in 2001. That the finding that in the context of Hobbs Act violation, which only requires a minimal effect on interstate commerce to support a conviction. Only minimal. So the defendants travel across states as part of a robbery scheme. It clearly demonstrates an effect on interstate commerce. So this was a robbery scheme that happened, and it supported minimal effect of the interstate commerce. But the government also presented evidence that the defendant used phones and instrumentality of interstate commerce to communicate with victims located in different states. Okay, so the defendant takes an overly narrow view of the law, maintaining that if the purpose of the enterprise was to promote defendants' illegal sexual activities and create pornography, the government was required to prove that those activities affected interstate commerce. Now, see document number 273 at 1 at page 22. As explained above, the purpose of the enterprise need not be criminal. On the contrary, a defendant may use a legitimate enterprise to commit crimes. Indeed, the defendant concedes that if defendant's legitimate music collective constituted an enterprise for RICO purposes, which it does, the government's argument would be well taken. And then it speaks about document number 282, and it's spoken about this at number 10. So the enterprise members communicated by phone with the defendant's victims. Now that too is sufficient to establish an effect on interstate commerce. Okay. Then it explains here about patterns of racketeering, which requires at least 2 acts of racketeering activity, one of which occurred after the effective date of this statute, and the last of which occurred within 10 years, excluding any period of imprisonment, after the commission of a prior act of racketeering activity. So the government must show that the racketeering predicates are related, and that they amount to or purpose a threat of continued criminal activity. And these requirements protect defendants from RICO charges based on isolated or sporadic criminal acts. But unfortunately, he had a pattern of behavior throughout the years. So it was nothing sporadic. And predicate acts must be related to each other and to the enterprise, which they were. The racketeering acts must be related to each other, horizontal relatedness, and they must be related to the enterprise, vertical relatedness. Continuity is both a closed and open-ended concept. So referring either to a closed period of repeated conduct or to past conduct that by its nature projects into the future with the threat of repetition. So the defendant disputes the evidence on every predicate act and the evidence of relatedness and continuity as to some acts. All right. So then it talks about the bribery. All right. Okay, Rule 29 motion where there are conflicts in the testimony. Okay, the court must defer to the jury's resolution of the weight of the evidence and the credibility of the witnesses. A jury is entitled to believe part and disbelief part of the testimony of any given witness. Now, in United States versus Flores, this is a case that happened in the Second Circuit in 2019. Smith was explicit that he did not want to testify. Yes, I don't want to be here, period. Now, Mr. Smith said
Yo, that shit almost fucking landed on
he did not want to testify, that he did not want to be here. We're talking about Demetrius Smith. Okay? Now, and that he was uncomfortable testifying about the defendant's marriage to Aaliyah. He said, and I quote, "I'm uncomfortable with this, Your Honor. I'm truly uncomfortable. We're continuously talking about Aaliyah. Her parents are not here, and I don't understand why I got to do that." Moreover, he was reluctant to incriminate the defendant, having known him since 1984 as just like his brother. A rational jury could credit the portions of Smith's testimony confirming the defendant's participation in the bribery and reject his conflicting testimony. Okay? Now, the defendant further argument that the predicate act of bribery lacks vertical and horizontal relatedness is also unpersuasive. As explained above, vertical relatedness may be established by evidence that the defendant was enabled to commit the predicate offenses solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise, or that the predicate offenses are related to the activities of that enterprise. In this case, the defendant was able to commit bribery because of his position as the head of the enterprise and his ability to direct the members of the enterprise to do his bidding. Further, the jury could reasonably find that the bribery was necessary to further the enterprise. Now, the marriage to Aaliyah protected the defendant, his image, and his career by shielding him from the consequences of having sex with a minor, prison, shame, and disgrace. The evidence also established horizontal relatedness. The defendant and his associates committed the bribery as part of and in order to facilitate the defendant's sexual activity with women and young girls, including illegal sexual activity. Now, it talks about the production of sexual explicit material as well.
Yeah, I was gonna take that selfie. You know that?
Okay.
Just took my fucking selfie.
Now, here in the footnote number 29, it says that the defendant also posits that because the act did not occur within 10 years of any other predicate act that was sufficiently proven, the act is time barred. Now, this is from document 273-1 that was submitted. And as explained below, the evidence was sufficient for the jury to conclude that the defendant was guilty of the charged offenses. As to the defendant's timing claim, the bribery took place in 1994, and the conduct alleged in Racketeering Act 2, which is the sexual exploitation of a child, Stephanie, occurred 5 years later in 1999, which clearly is less than 10 years apart. In any event, Section 1961(5) requires only that the last predicate act happened within 10 years of another predicate act. And then it cites another case law from the Eastern District of New York, in 2012, saying that finding that predicate act that occurred more than 10 years before the next predicate act could still be considered part of a pattern of racketeering activity where the last predicate act occurred within 10 years of a prior act. Now, these two acts in 1994 and 1999 only happened within 5 years of each other. So therefore, this is a horizontal or vertical act, whichever one it was she said. They said. Okay? So the defendant does not deny the evidence that he taped his sexual encounters with these 3 victims. Okay? He did not deny. The defendant does not deny the evidence that he taped his sexual encounters with these 3 women, which are from Racketeering Acts 2. For Stephanie, Racketeering Act 7 for Geronda, and Racketeering Act 10 for Jane. Now, he was charged with sexual exploitation of a child for these 3 girls at the time when they were girls, because they were children under the age of 18.
But sometimes you can shoot these niggas and they don't
16,
die,
16, and 17. They were under the age of 18. And that is part of the 18 United States Code, sections 2251A, to where the government was required to prove that, 1, the victim was less than 18 years old. They did prove that by proving their birth certificates and showing how old they were.
And then you have one coming up on the side next to you.
It's in the discovery. 2, the defendant used, employed, persuaded, induced, enticed, or coerced the minor to take part in sexual explicit conduct for the purpose of producing a visual depiction of that conduct. So he persuaded the girls by saying, I'm going to give you something. He employed the girls by giving them $5,000 a monthly stipend. He used the girls to do whatever he wanted them to do. He enticed them with the money.
You want me to entice you with some money? Ooh, I entice you with some money.
And coerced the minor to take part in sexually explicit conduct for the purpose of producing a visual depiction of that conduct. And 3, the visual depiction was produced using materials that had been transported in interstate or foreign commerce. The materials being his iPads, his iPhone, his cameras that he put in his backpack and he would carry with him from tour to tour, venue to venue, place to place, the gym to the McDonald's, from one state to the other state. He was traveling with his backpack, like Diego. Fuck. And the defendant does not deny the evidence that he taped his sexual encounters with these victims, with these 3 victims, nor does he dispute that they were minors at the time he taped them. Instead, he's claiming that the government had to prove that defendant did something more than just film the sexually explicit conduct. And this is in document 273-1 at 28. He contends that the government did not prove that he did anything to persuade, induce, entice, or coerce Stephanie, Geronda, or Jane into the sexual activity that was recorded. And he speaks about this again in document 273-1 at 28, 35, and 51. and there's an emphasis in original. The defendant misstates the applicable law and the facts established at trial. That a defendant can be found to have used a minor to produce child pornography if the minor serves as the subject of the illicit photographs taken by the defendant. And there was a case, the United States versus Searles, in 1996. Okay. Also, 2 more cases underneath that, maybe 3, that are the same, that state as a defendant concedes, several circuits, including the Second Circuit, have held that the element set forth in 2251 is satisfied with the defendant's. Hold on a second, guys. Okay, guys, sorry about that. Had to use the restroom as well. Had to speak to mom and my daughter. Okay. All right, so let's get back into it. Okay, so what was I am? Okay, so again, he contends that the government did not prove that he did anything to persuade, induce, or entice the girls into sexual activity that was recorded. Now, the defendant misstates the applicable law and the facts established at trial. A defendant can be found to have used a minor to produce child pornography if the minor serves as the subject of the illicit photographs taken by the defendant. Then it states a bunch of laws, state laws, as I said, that are the same. As the defendant concedes, several circuits, including the Second Circuit, have held that the use element set forth in 2251A is satisfied when a defendant intentionally films a minor's sexually explicit conduct. Now, it talks about that in the document 282 at 11. Nevertheless, the defendant argues that the Second Circuit's interpretation would render the remaining terms in the statute, persuade, induce, entice, or coerce, superfluous. I don't even know if I'm saying that right. Superfluous. Now, it talks about that in document number 282 at 11 and 12. But district courts are bound to follow controlling Second Circuit precedent unless that precedent is overruled or reversed. And it talks about that in another case, stating that thus this court is bound by the Second Circuit's holding in Syros. In any event, the defendant's challenge is meritless. It means shit. Section 2251A requires proof of active or coercive conduct by a defendant upon a minor. Now, the broad interpretation of use applies when a defendant engaged in active conduct. For example, if the defendant photographs or films a minor or directs the photography or filming of a minor. See Syros, finding that the use element was satisfied where the photographs were taken by the defendant. Finding that the use element was satisfied where the defendant directed the minor's actions. A defendant may engage in coercive conduct and persuade, induce, entice, or coerce a minor to produce child pornography. For example, by persuading a minor to take pornographic photographs of herself or himself. Finding that the government had not adduced sufficient evidence that certain pornographic photos taken by a minor were taken at the defendant's behest. So accordingly, the words persuade, induce, entice, or coerce in section 2251 are not rendered meaningless by the Second Circuit's interpretation of use. Now, in this case, in any case, the defense argument is foreclosed by evidence showing that the defendant engaged in persuasive and coercive conduct with Stephanie, Jane, and Geronda. They testified, as did other witnesses, about the punishments that the defendant exacted when they broke his rules, and the physical and emotional manipulation they endured to meet the defendant's sexual demands.
I'm trying to watch the right side.
So
I got
when
an
R.
Amazon.
Kelly had that audio recording,
I got an Autobot.
What for lunch?
wait, when Lisa Van Allen had that recording, when R. Kelly had that recording of Lisa Van Allen and telling her,
It's mighty. It's one of
Bitch.
my names, mighty. I'm here to save the day.
you did this wrong, you did that wrong, you better do it right the next time or I'm gonna fuck you up.
Those are the niggas running from the right.
And on top of that, you stole from me.
Yo. That's a place.
Right then and there goes proof that the defendant was using coercive, persuasive control.
Oh, that's you. My bad. That's you.
He used force, threats of force.
Yo, top of the roof. You got a bunch of them.
Now, based on this testimony, a reasonable juror could find that the defendant similarly persuaded or coerced the victims to engage in the sexual explicit conduct. The defendant also argues that the government did not prove that he acted with a purpose of producing a visual depiction, and that the jury charge on this element was wrong. And that's talked about in document 273-1 at 28. Now, an examination of the charge itself, to which the defendant did not object. Again, an examination of the charge itself, to which the defendant did not object, refutes that claim. Now, the court explained that Racketeering Acts 2, 7, and 10 charge the defendant with using a minor to engage in sexual explicit conduct for the purpose of producing one or more visual depictions of such conduct. And the court then quoted the relevant portion of 18 U.S.C. 2251, which provides that a person who employs, uses, persuades, induces, entices, or coerces any minor to engage in any sexual explicit conduct for the purpose of producing any visual depiction of that conduct shall be punished. If such person knows or has a reason to know that the visual depiction will be transported in interstate or foreign commerce or mail, if that visual depiction was produced using materials that had been mailed, shipped, or transported in interstate or foreign commerce by any means, including by computer, or if the visual depiction had actually been transported in interstate or foreign commerce or mailed. So R. Kelly carrying them backpacks full of videos fucked them up. Finally, the court discussed the elements that the government had to prove. To prove that the defendant committed this racketeering act, the government must prove the following three elements beyond a reasonable doubt. First, that Stephanie was under the age of 18 at the time of the acts alleged in the indictment. Second, that the defendant used, employed, persuaded, induced, or enticed Stephanie to take part in sexually explicit conduct for the purpose of producing or transmitting a visual depiction of that conduct. Third, that the visual depiction was produced using materials that had been mailed, shipped, or transported in affecting interstate foreign commerce. While the government must prove that the defendant acted with the purpose of producing a sexually explicit visual depiction, the government does not need to prove that a visual depiction of sexually explicit conduct was actually produced. So the court's charge, viewed in its entirety, made it clear that the jurors had to determine whether the defendant's purpose was to produce a visual depiction. Accordingly, the jury instructions, taken as a whole and viewed in light of the evidence, show no tendency to confuse or mislead the jury as to principles of law which are applicable. Finally, the defendant maintains that the government failed to prove the interstate commerce element, that the visual depictions were produced using materials that had been mailed, shipped, or transported in interstate or foreign commerce for Racketeering Acts 2 and 7. And it speaks about this in the document 273 at 29 and 35. Now, this claim is also unpersuasive. Stephanie testified that the defendant filmed her in Illinois using a video camera with VHS tape. The defendant acknowledges that the parties stipulated that the type of film used in VHS tapes was not produced in Illinois during the relevant time period. And you can see that example in 273.1 at 29, talking about the government's exhibit 1006. That is sufficient to satisfy the interstate commerce element. Now, interstate commerce element met where component of videotape at issue was manufactured out of state. Okay, hold on one second. Sorry about that, ladies. Sorry about that. Hey, Top Notch. What's up, lady? The truth. You want to break, mama? Okay, baby. Just the tea. What's up, lady? Tasha. What's up, Tasha? What's up, Queen? Queen Brielle? Bree? Queen Bree. What's up, Queen Bree? Brielle. I'm sorry if I chopped up your name, sweetie. Okay. All right. Just saying what's up to everybody. What's up to those on Facebook? What's up? What's up? What's up? Okay. Let's go back to this. All right. So Geronda testified that the defendant made a recording of her in Illinois using an iPhone and a Canon camera. Despite this testimony, the defendant claims that the government did not establish what device, if any, was used to making these recordings, and therefore its affecting interstate commerce evidence was insufficient. So these are the things, like I'm saying, that Bonjean is going to bring up in her argument. That's why I'm reading these, and I'm just kind of going through this stuff briefly just to give you a synopsis, a summation of what Bonjean is going to bring up in her brief when she does it right. All right. However, the jury was entitled to credit Geronda's testimony about the devices the defendant used and the government's evidence that both devices were produced out of state. Government's Exhibit 1006, 957, and then it was spoken about in the trial transcripts, and that accordingly there was sufficient evidence to convict the defendant of the racketeering acts 2, 7, and 10. Okay, now the exposure to a sexually transmitted disease intent, right, which is the racketeering acts 8A for Jane, racketeering 12A for Faith, and 14A for Faith. Okay, now it charged the defendant with transporting a person in interstate commerce with the intent to engage in sexual activity that exposed the person to herpes, which violated certain state criminal and public health statutes. Now, in the Title 18 United States Code 2421A says that whoever knowingly transports any individual in interstate or foreign commerce with intent that such individual engage in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be punished. So the defendant claims that the government did not prove that he transported Jane or Faith with the intent of exposing her to herpes. And again, in document 273-1 at 36 and 54 is where this is stated. And once again, the court charged the jury on the element of intent, a charge to which the defendant did not object to it. Now, in order to establish this element, it is not necessary that the government prove that engaging in illegal sexual activity was the only purpose for crossing the state line. Now, a person may have several different purposes or motives for such travel, and each may prompt in varying degrees the act of making the journey. So the government must prove beyond a reasonable doubt, however, that a significant or motivating purpose of the travel across the state line was that the defendant would engage in illegal sexual activity with the victim. In other words, that illegal activity can't have been merely incidental to the trip. Now, racketeering acts 12A and 14A correspond to counts 6 and 8, respectively. Now, the defendant maintains that the illegal sexual activity must be the dominant purpose of the travel, as opposed to merely a significant or motivating purpose. And it is spoken about in document number 273-1 at number 37. That is not the standard in this circuit. So the word dominant does not appear in the statutory language. Now, courts in this circuit have adopted the significant or motivating purpose standard. And it states a case, okay, using the 18 U.S.C. 2421, approving significant or motivating purpose standard. And it talks about the United States versus Maxwell. Okay, and that's Ghislaine Maxwell's case, okay, which was part of the Southern District of New York in December 19th of 2021, that using significant or motivating purpose standard in jury charge for violation of 18 U.S.C. 2423A states that transportation of a minor with intent to engage in illegal sexual activity. And it says another case, United States versus Hayward in 2004, proving the same standard in the 18 U.S.C. 2423A case. Now, the defendant, Rkelly, does not challenge that the evidence at trial demonstrated he contracted genital herpes between 2000 and 2007, that his doctor, Dr. Chris McGrath, informed him of the diagnosis, and that Dr. McGrath told him to use a condom during sexual intercourse and to let his sexual partners know of his diagnosis. Nor does he appear to challenge that the evidence showed that he never used a condom during sex with Jane and Faith, and that he never told Jane and Faith that he had been diagnosed with herpes. Rather, the defendant argues that there is no evidence that defendant's actions of arranging for Jane and Faith to travel to meet him was motivated by an intent to expose Jane and Faith to STDs, rather than simply have sex with them. And this is spoken about in documents number 282 at 12 and 13. Okay, also see document 273 at 1 at 54. Because the defendant's purported violation of the New York public health law prohibiting him from exposing a partner to herpes was incidental to Faith's trip, rather than a motivating purpose in transporting Faith, the intent requirement of the statute cannot be sustained. So the plain language of 18 U.S.C. 2421 requires that the defendant transported Jane and Faith with the intent that they engage in sexual activity for which any person can be charged with a criminal offense, thus as the court instructed the jury. So the government was required to prove that the defendant transported Jane and Faith with the intent of engaging in sexual activity with them, and that the intended sexual activity was illegal. The record established, and the defendant appears to concede, that his motivation in arranging for Jane and Faith to travel to meet him was to engage in sexual activity with them. In light of Jane's and Faith's testimony, as well as other witnesses' testimony about their sexual experiences with the defendant, the jury could reasonably conclude that the defendant intended to have sex with them without a condom and without informing them that he had herpes. And as explained in section 1A III 5 below, the defendant could be charged with criminal offenses for that sexual activity because he exposed Jane and Faith to genital herpes, which violated state, criminal, and public statutes in existence at the time. Accordingly, the evidence was sufficient to prove the intent element. Give me 1 second, guys. Why does it smell like something's burning?
There's something on the bottom of the oven. Let's go. somebody over.
All right. Okay, so the next thing is the exposure to sexually transmitted diseases, persuasion, inducement, enticement, or coercion. Racketeering Acts 8B with Jane, and Racketeering Acts 12B with Faith, and 14B with Faith. It charges the defendant with persuading, inducing, enticing, and coercing a person to travel in interstate commerce to engage in sexual activity that exposed the person to herpes, which violated certain state criminal and public health statutes. Okay. Now, when it comes to this part, the defendant asserts that there is no evidence that he took any action to induce, persuade, entice, or coerce Jane into traveling to California in April through May of 2015. Instead, he says, citing text messages between Jane and her mother, that the record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter. And this is mentioned in document 273-1 at 41. And it talks about the government exhibit 233, which we all know is the text messages that we have been reading and also people have read online so far between Jane and her mom. Now, according to the defendant, he merely invited Jane to join him, and she excitedly accepted. And it talks about this in 273-1 at 47. Now, in his challenge to the evidence about faith, he maintains that he invited a grown woman to meet him in New York, and she accepted. So he's challenging that the fact that Faith was grown and he invited her and she accepted. And then he's saying that Jane, when she went traveling to California in April through May, that the mom was the one who enticed the daughter to go. That she strategically enticed her daughter to go. Now, the words persuade, induce, entice, or coerce, though not defined in the statute, are words of common usage that have plain and ordinary meanings. And it cites a case. Now, Section 2242 imposes no requirement that an individual endeavor to transform or overcome the will of his intended victim. In fact, the jury need only consider whether the defendant intended to induce, persuade, or entice the victim to travel to engage in sexual activity with him, regardless of whether she expressed or felt reluctance, indifference, or, for that matter, enthusiasm at the prospect of doing so. So it doesn't matter, regardless of whether she said, I don't know, or no, or maybe, or yes, I will go. The jury was entitled to conclude from the evidence that the government proved the elements of these charges. As Jane testified, the defendant made it clear from their first meeting when she was a junior in high school that his interest in her was sexual. Thus, he persuaded her to engage in sexual contact with him, telling her he needed to ejaculate before she could audition for him. He also told Jane that he wanted to see her again and teach her a few techniques. He proposed that she meet him in Los Angeles, California, and gave her the number of his assistant, Cheryl Mack, so that Mack could make the travel arrangements for which he paid. Now, those text messages that the government submitted, portions of it, all they wanted was travel arrangements, the itineraries, and who said who to who. Back and forth between the assistant and the victim. Mr. Kelly said, "Please make an arrangement for me. Thanks." Mr. Kelly wants you to meet him backstage.
Every time I kill somebody, somebody else got. Come on, you fucking dick. Right?
Mr. Kelly wants me to call you and tell you I want food.
You know, you get a kill and all of a sudden, motherfucker, right there.
That's why they used the text messages. They wanted to just prove that. It had nothing to do with anything else. Now, the defense could have used those text messages to debunk whatever they wanted, but they really didn't. They only used certain portions of it. And it's because they couldn't prove any extortion from Rkelly to the parents. I mean, from the parents to Rkelly. None. Now, similarly, it was clear that the defendant was interested in having sex with Faith when she met him after his San Antonio, Texas concert in March of 2017. After the defendant gave Faith his contact information, they communicated regularly. The defendant told Faith that he loved her and invited her to meet him while he was on tour so that they could hang out, which would be fun. As he did with Jane, the defendant gave Faith Diana Copeland's number. Faith contacted Copeland, who arranged her travel to New York in May of 2017. The defendant paid for the flight. Copeland also booked the defendant's paid for her trip to New York in February of 2018. Now, a reasonable jury could find that the defendant did far more than simply invite Jane and Faith to meet him, and that he persuaded, induced, or enticed Jane to travel by offering incentives, suggesting that he would teach her singing techniques, and by offering to make and pay for the necessary travel arrangements. The jury could also rationally find that the defendant persuaded, induced, and enticed Faith to travel in May of 2017 by telling her that he loved her, by assuring her that the trip would be fun, and be arranging and paying for all of her travel. The fact that Jane and Faith may have been willing or even eager to travel is not relevant. Oh, I don't know. Hold on. I'm about to end this live now. So now he talks about exposure to sexually transmitted disease. They're going to discuss Racketeering's Act 8 and 12 for Faith and Jane, about the New York penal law.
Shotgun's good for fucking close up. That's just not a long range gun. Some people act like that's a long range gun.
Okay. All right.
Yo, niggas drop mag guns over there.
Let's see. Okay, still talking about the. Okay. Now, in any event, the defendant's arguments are without merit. Okay, wait, hold on. Okay, hold on. I'm just gonna kind of. Okay. The defendant has not adequately explained his failure to raise his current arguments about CHSC, the charges of the I forgot what it's called again. The diseases. For the California statute, right? The defendant has not adequately explained his failure to raise his current arguments about the CHSC 12290 earlier. His only justification is that the government did not apprise the defense of its intent to have the jury charged pursuant to repealed version of the statute that it also rewrote. So she's complaining about the statute and how it was rewritten and it doesn't apply. And she talks about that in document 298 at 2. Joshua! But the information supporting the defendant's challenges was reasonably available to him as early as March 12th of 2020, when the superseding indictment was returned against him, making clear the government charged the 1998 version rather than the 2018 version. On July 2nd, 2021, little more than a month before the trial, the government submitted proposed jury instructions, which also alerted the defendant that the charge was based on the 1998 version of the statute. The information the defendant cites for his vagueness argument was also available to him before trial. So the indictment currently at issue is the same document defendant reviewed before trial. So if that document is vague now, then it was vague then, which is when defendant should have voiced his concerns. In fact, the defendant raised vagueness arguments about the New York law in his pretrial motion to dismiss and to strike. He could have made similar challenges to the Chicago one, which he did not. And that talks about that in the document number 69. Now, the defendant has not established good cause for his failure to challenge the California Rule 12 motion. Accordingly, not only are the defendant's constitutional claims about the California one beyond the scope of Rule 29 motion, they are also untimely and, as a result, waived. So in any event, the defendant's arguments are without merit. He challenges the 1998 version of the statute on as applied the factual grounds, arguing that it fails to provide adequate definitions that put individuals with any chronic and potentially contagious diseases on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. And he talks about that in document 273 at 40. Now, he theorizes that anyone with herpes simplex 1, also known as cold sores, who kisses another person without disclosing that they have herpes simplex 1 is guilty of a misdemeanor. So the defendant is forced from challenging the California law for vagueness, either on and as applied on the factual basis. Now, the due process clause of the 14th Amendment requires that every criminal statute, number 1, give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, and 2, provide explicit standards for those who apply the statutes. Now, a criminal statute is unconstitutionally vague in violation of due process if it fails to give ordinary people fair notice, or is so standardless that it invites arbitrary enforcement. Even if there is ambiguity as to the margins of what conduct is prohibited under the statute, it is clear to an ordinary person that the California law would prohibit the defendant's conduct having unprotected sex, knowing he had herpes, without informing his partner. Moreover, an as applied vagueness challenge supported by the law's potential for arbitrary enforcement must fail if the enforcement is at issue is consistent with the core concerns underlying the statute. The defendant's conduct falls within the 120 290's clear core, protecting the public from the spread of infectious venereal diseases. All right. All right. So she's going to fight about all that. Okay. Finally, the defendant argues that even if the elements of the statute were, as the government alleged, insufficient evidence existed to sustain the charge. And it talks about that in document 273-1 at 40 and 41. The defendant makes the same claims he makes about Racketeering Act 12 with faith that there was no evidence that he was contagious, infected, or had the capacity to transmit herpes when he had sexual contact with Jane in 2015, and that the government cannot show that he acted willfully with knowledge of the consequences. These claims, the only claims about this conduct that are cognizable in Rule 29 motion, have no merit. Jane testified that she contracted genital herpes after the defendant had unprotected sex with her in summer of 2015. She experienced discomfort in her pelvis and in her lower abdomen, and saw a doctor in August of 2015 when her symptoms got worse to the point where she couldn't even physically walk. The doctor diagnosed her with herpes and prescribed her medications. When the defendant told her that she could have gotten that from anyone, she responded that she had been intimate only with him. Jane's medical records also reflect that the defendant was her only sexual partner. Jane's testimony, as well as the evidence that the defendant infected multiple other victims with herpes when he had sex with Jane in 2015, and that his act in exposing Jane to the disease was willful or purposeful. The word willfully, when applied to the intent with which an act is done, or it implies simply a purpose of willingness to commit the act or make the omission referred to. It does not require any intent to violate the law or to injure another or to acquire any advantage. Internal quotation marks and citation admitted. Okay, so sexual activity with minors. Racketeering Acts 5, Geronda, and 9, Jane, charged the defendant with the Mann Act violation based on sexual activity with minors. Okay. To convict the defendant under this, the government had to prove that the defendant used a facility of interstate commerce to knowingly persuade, induce, or entice any individual who was younger than 18 years old to engage in sexual activity of a criminal nature. Okay, with respect to Racketeering Act 5, the government charged the defendant with violating Illinois Criminal Code 5/12-16D, which provides that an individual commits aggravated criminal sexual abuse if he or she commits an act of sexual penetration or sexual conduct with a victim who was at least 13 years of age, but under 17 years of age, and the accused was at least 5 years older than the victim. So the defendant contends that the government did not prove the first element. Give me 1 second, guys. Josh! Okay. Sorry, guys, about that. Yo. Jennifer's asking the court, can she submit a brief with over 25,000 words? Okay. All right, so let's see now. Now, the defendant contends that the government did not prove the first element, the use of a facility of interstate commerce, because purely intrastate use of cell phones does not constitute use of a facility of interstate commerce. However, the Second Circuit has interpreted use of a facility of interstate commerce to include intrastate use of that facility. Prohibition on the transmission of the name of a minor using any facility or means of interstate commerce for the specified purposes, including the intrastate use of such a facility of means. Finding that wholly intrastate communications made using a national telephone network constituted use of a facility of interstate commerce. Accordingly, intra-cell phone calls satisfy the first element of Section 2422B. Next, the defendant asserts the government did not show a nexus between the use of the interstate facility and the persuasion, coercion, enticement, or inducement. Geronda testified that she attended a party at the defendant's Olympia Fields residence in May of 2009 and exchanged phone numbers with the defendant. They communicated by text messages and phone calls. She went to his home every time she was invited. During the 6-month period she spent with the defendant, she had sexual contact with him every time she was there. On one occasion, when Geronda was at the defendant's house, he called her and told her to get in his tour bus and directed her to have sex with him and Juice. This evidence was sufficient to show that the defendant used interstate commerce to persuade, induce, or entice Geronda. Now, a rational jury could also find that the defendant did persuade, induce, entice Geronda to engage in sexual conduct. Words like persuade, induce, and entice are all words of causation. Causitation. The evidence from multiple witnesses, victims, and members of the defendant enterprise established that the defendant implemented strict rules in and out of his home, that he expected that his victims and employees obey his commands, and that he exacted punishment for perceived violations. A rational juror could infer from the defendant's direction to Geronda to leave his house and go to his tour bus that he induced or coerced her into having sex with the defendant and Juice. Okay, now finding inducement where the jury could have inferred that the defendant made a request for an additional video of a minor with the intent to cause or bring out the creation of that video. Josh, take what you want. Okay. Equally unpersuasive if the defendant's argument that no reasonable juror could conclude that the defendant knew that Geronda was 16 years old when they allegedly engaged in sexual activity between May of 2009 and January of 2010. Geronda testified that she told the defendant the first time they engaged in sexual activity that she was 16 years old and showed him her ID. The jury was entitled to credit her testimony and find that the defendant did not believe that Geronda was 17 years or older when he had sex with her. Now, investigators searched the defendant's storage facility and found a forged birth certificate and a state ID card in Geronda's name. And that's Government Exhibit 413 and 414. Both stated that she was born in 1990 rather than 1993, the actual year of her birth. Okay?
Yeah, I pistol whipped them. You fuck out of here. Suck a dick, bitch.
So, Racketeering Act 9 has to do with the Mann Act violation.
See that?
The California penal law.
He had a little hair of energy.
Okay. All right. So, okay. Based on the violation of the California penal law, which provide that any person who engages in any act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty. Where unlawful sexual intercourse is an act of sexual intercourse accomplished with the person who is not the spouse. With a person who is not the spouse of the perpetrator. If the person is a minor, and a minor is a person under the age of 18 years old. The defendant acknowledges Jane's testimony that she told the defendant her true age, 17 years old in 2015, but argues that the evidence was nevertheless insufficient because the record does not reflect precisely when she told defendant her true age. Now, Jane testified that she told the defendant she was 17 years old in Chicago when summers end, and she had to go back to school for her senior year in high school. She returned to Florida but moved back to Chicago and then joined the defendant on his tour. Moreover, the letter from Jane's parents authorized Juice's mother to be Jane's guardian until she turned 18 years old, was dated September 19th of 2015. And that is part of the government's Exhibit 475A and 476A. And Suzette Mayweather testified that the defendant and his entourage left New York for California on September 29th, 2015. Based on this evidence, a rational juror could conclude that the defendant knew Jane was less than 18 years old prior to their California trip. With respect to the Racketeering Acts 9B, the defendant maintains that there is no evidence that he took any action to induce, persuade, or coerce Jane to travel to California between September and October. Now, in a footnote, the subpredicate Racketeering Acts 9A, 9B, 9C, and 9D correspond to counts 2, 3, 4, and 5, respectively. In challenging the government's proof for Racketeering Act 9A, the defendant mistakenly incorporates by reference his arguments in connection with Racketeering Act 8A, which was based on a violation of the CHCS 12290 for willful exposure, the California health law. Racketeering Act 9A, on the other hand, was based on violations of sections 261.5A and 261.5B of the criminal penal law, the California penal law. Okay? As explained previously, the government did not need to prove that the defendant overcame Jane's resistance or that Jane did not want to travel. The evidence showed the defendant arranged for Jane to enroll in virtual schooling and for Juice's mother to serve as her legal guardian. The defendant paid for Jane to travel back to Chicago Now, she subsequently traveled with the defendant from city to city for his shows. Accordingly, a reasonable jury could find that the defendant persuaded, coerced, induced, or enticed Jane to travel to California. In his challenge to Racketeering Act 9C, the defendant also asserts that there was no nexus between the use of the facility of interstate commerce, a cell phone, a computer, and the words persuasion, entice, or coercion. However, the defendant enticed Jane to travel from New York to California in October of 2015. She used interstate highways, including the I-80, which courts recognize as a facility of interstate commerce. Okay, noting that the interstate highway is an example of an interstate commerce facility in a Mann Act case. Noting that an interstate highway is an instrumentality of interstate commerce for purpose of the Hobbs Act. Now, a reasonable juror could therefore conclude that the defendant used facilities of interstate commerce in the course of his criminal conduct involving Jane. Now, with respect to Racketeering Act 9D, Title 18, Code 2423A, the defendant argues that his purpose in traveling to California was to perform, and he arranged for his girlfriend to go with him, and any sexual activity was purely incidental to the purpose of the trip. Now, Jane testified that she and the defendant had sex almost every day in the summer of 2015, and that they had sexual contact while traveling on tour. Now, the jury was entitled to rely on Jane's testimony as well as testimony from the defendant's other sexual partners and conclude that sexual activity was the defendant's significant or motivating purpose when he arranged Jane's travel with him. Then the forced labor with Racketeering Act 6 with Geronda, 11 for Jane, and 13 for Faith. It charged the defendant with forced labor, which is the U.S. Section Code 1589A, that whoever knowingly provides or obtains the labor or services of a person, 1, by means of force, threats of force, physical restraint, or threats of physical restraint to that person or another person, 2, by means of serious harm or threats of serious harm to that person or another person, 3, by means of the abuse of threatened abuse of law or legal process, or 4, by means of any scheme, plan, or pattern intended to cause the person to believe that if that person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint shall be punished. So by Rkelly giving them spankings and making her eat feces and then saying, no, you fucked up, you got to do it again. No, you fucked up, you do it again. No, rub it, eat it. That's all forced labor. If you don't do this video right, we're going to have to do it again. If not, I'm going to fuck you up. That's forced labor. Putting a gun on the side and saying, suck my dick. That's forced labor. Okay? Now, the defendant makes multiple attacks on the evidence supporting the jury's verdict on Racketeering Act 6 with Geronda, 11 with Jane, and 13 with Faith. That the theme of these attacks is that there was no evidence that the defendant coerced his victims to do what was charged in the Forced Labor Racketeering Acts. In fact, victims' testimony provided a rational basis for the jury's conclusion that the defendant was guilty of the charges. Moreover, the jurors had a larger context in which to place the testimony of the individual victims. Not only did the victims support one another's testimony, the additional evidence that the jurors heard corroborated what the victims described. Thus, they heard and saw vivid evidence of the defendant's means and methods of domination and control. A videotape in which he forced Anna to walk back and forth completely naked, calling herself a slut and stupid, while the defendant smacked her. And that is Government Exhibit 328A and 328B. An audio tape in which the defendant convinced that Kayla had stole from him, ordered her to describe what she had done, berated her for holding back on a videotape, and then directed her to go to the closet in his garage and said, when I come and get you this time, you better be fucking like you're supposed to fucking be. You better be fucking like you're supposed to fucking be. And that's Government's Exhibit 485. The defendant's employees, too, were well aware of what the defendant did to his victims, as evidenced by the text exchanges between the Mayweather sisters describing the defendant's treatment of Jane. In short, the evidence supporting the charges was more than sufficient to establish the defendant's guilt, and his attacks on the proof are nothing more than disagreements with the jury's resolution of the evidence. Nevertheless, I address each claim in turn. So, as to Racketeering Act 6, the defendant argues that the government did not establish a casual link between the isolated act of oral sex with Geronda and any threat of physical violence. As explained multiple times in this opinion, Geronda, like other witnesses, testified that the defendant required her to follow his rules, that he severely punished her when she broke them, slapped her when she disagreed with him, and when she questioned his direction to use sex toy, and when she questioned his direction to use a sex toy on him, ordered her to write a letter to gain his trust in which she falsely admitted that she stole $100,000 worth of jewelry. And then in January 2010, the defendant was angry that Geronda did not greet him. He slapped her, choked her into unconsciousness, spit on her face, and told her to put her head down in shame. Finally, he forced her to perform oral sex on him and ejaculated on her face. The graphic testimony about the defendant's rules and the consequences of breaking them obviously gave the jury a reasonable basis to infer that Geronda complied with the defendant's orders because she feared that he would hurt her if she disobeyed. That's forced labor.
Sitting in the corner, Don.
Okay?
Yeah, this fucking bitch ass. Curse him out. Curse him out.
I gotta get ready to cook, so I'm gonna okay. So, like I said, these are the things that Bonjean is going to be arguing in her brief. Okay, so here now she talks about a motion for the new trial. All of that we were talking about had to do with Rule 29 for the acquittal. Okay, so now she's also going to motion for the new trial. Okay, this is going to be part of her brief as well, where in this part she talks about how the court may vacate any judgment and grant a new trial if the interest of justice so requires. The court has broad discretion to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. By that discretion should be exercised sparingly and in the most extraordinary circumstances. Now, because motions for a new trial are disfavored in this circuit, the standard for granting such a motion is strict. So in considering whether to grant a new trial, a district court may itself weigh the evidence and the credibility of witnesses, but in doing so, it must be careful not to usurp the role of the jury. So the court should grant a Rule 33 motion only if letting a guilty verdict stand would be a manifest injustice because of a real concern that an innocent person may have been convicted.
Fuck, man? This nigga's down. He's resin his man. Bro.
Now, the defendant's arguments provide no basis for this extraordinary relief. So what he is fighting for the new trial has to deal with ineffective assistance of counsel, which has to do with the voir dire, which is the jury selection process. Okay? So the defendant attacks the performance of his trial lawyers during the voir dire process, finding fault with 8 of the 12 regular jurors, with 1 alternate juror who did not deliberate. And the defendant claims that his counsel did not do a meaningful voir dire of potential jurors and should have probed more by asking additional questions and challenging certain jurors as unqualified. So this argument fails for multiple reasons. Okay? I got to get ready to cook, guys. I got to end this live. So basically, her new trial motion has to do with ineffective counsel. That has to do with the jury selection. Okay? And then the Rule 29 for an acquittal has to do with his charges. Certain charges that had to do with Jane, Faith, and Geronda. Okay? Thank you, Karen, for the super chat. Thank you, mi amor. Gracias. For those who did donate, thank you so much, guys. I appreciate y'all. So that's what they're talking about here, about the jurors for the new trial. She's also going to bring up the conflict of interest that had to do with the Curcio hearing. Okay? She will also be bringing up the evidentiary rulings. Okay? The defendant challenges the court's evidentiary rulings and claims that the court permitted irrelevant and excessive bad character evidence. So she's also going after the bad acts, which were the 14, I think, other uncharged acts, okay, that came in. You know, and then what else? So she's talking about Angela's testimony, the evidence that the defendant exposed other women to herpes.
Went upstairs.
What else? She's also going to go after the testimonies by Addie, Alex, Kate, Anna, Angela, Lewis, and Alex about these 7 additional witnesses.
I'm lagging, bro, big time.
Okay.
I go to fucking, my gun is reloading on its own.
So she challenges these testimonies as cumulative and unduly prejudicial, and faults the trial counsel for not competently objecting to it. So she's arguing that the government should not have brought these people in because it's prejudicial, as well as the fact that she's arguing that the defendant's arguments do not warrant relief under the 33, saying that at the trial, his lawyers were competent.
He has a mic.
And that they had faults.
If I'm correct,
His counsel had faults at trial because they didn't object to what they needed to object to the right way. Okay? Okay. She's also going to argue about the video exhibits. Okay? She's going to argue that the defendant also disagrees with the court's decision to admit certain graphic video evidence. Okay? And she talks about this in her document that she submitted in New York, document number 276 at number 11, that the government exhibits 341 through 343 depict sexual encounters between Alex, Dominique, and the defendant. Now, government exhibit 341, 342, and 343. In one of these recordings, the defendant guided Dominique's head while she performed oral sex on Alex. And then in government exhibit 328A, the defendant spanked Anna, who was naked, while she walked back and forth, crying and robotically repeating that she was a slut and stupid.
I was in the air.
Now, government exhibit 328A,
it's funny.
and in government exhibit 329A, a 9-minute recording of which the jury saw only a few minutes of, Anna is spreading feces on her naked body and called the defendant daddy.
I'm warmed up and I still play like shit.
Now, the defendant objects that this evidence was not relevant to any means and methods of an enterprise, since there was no enterprise. And whatever probative value it had was substantially outweighed by its prejudicial effect. Now, the video depictions of sexual activity between Alex, Dominique, and the defendant were properly admitted into evidence. Okay? First, the evidence showed the control that the defendant exerted over his victims, and therefore demonstrated the means and methods of the enterprise alleged in the indictment.
I'm trying to jump out the window,
and that's on document number 43, 7 through 9. The defendant directed Alex and Dominique, whom Alex described as zombie-ish, how to have sex and what to do to each other and how to react. Second, the videos were direct evidence of one of the purposes of the enterprise to recruit.
I try to reload and catch him,
but to recruit women and girls to engage in sexual activity with the defendant, as well as to produce pornography. Hold on a second.
Is the camera on?
All right, my daughter just came in from hanging out. All right, let me go back to this. All right, after this, I'm going to end this, guys. I really have to end this. Okay. How to react. Now, second, the videos were direct evidence of one of the purposes of the enterprise to recruit women and girls to engage in sexual activity with the defendant, as well as to produce pornography. Third, the video evidence corroborated Alex's testimony and provided support for the testimony of other victims, including Jane and Lewis, that the defendant required them to have sexual contact with others, which the defendant filmed. The videos were admissible under Rule 403 because they were relevant and probative and not unduly prejudicial. The exhibits corroborated the trial testimony and were no more inflammatory than the offenses with which the defendant was charged. Now, the video recording of the defendants punishing Anna, while graphic and disturbing, was properly admitted under the Rule 404B, and its probative value was not substantially outweighed by any risk of unfair prejudice. So the means and the methods of the enterprise included, among other things, demanding absolute commitment to the defendant and not tolerating dissent, obtaining sensitive information about sexual partners and members and associates of the enterprise to maintain control over them, and creating embarrassing and degrading videos of sexual partners to maintain control over them. Now, the video recording of Anna, Government Exhibit 32A, was direct evidence of the enterprise and the way it operated. It was an embarrassing and degrading video, which the defendant created and demonstrated the force he used to control his victims, spanking them and ordering them to say degrading things about themselves. The video also corroborated Anna's testimony as well as Jane's and Geronda's about the ways that the defendant punished them for breaking his rules. Okay? Now, the second video exhibit, also explicit and horrifying, was similarly admissible as evidence of the ways in which the defendant used humiliation and punishment to control his victims. The recording supported Anna's testimony that the defendant made her do dehumanizing, humiliating acts involving bodily fluids. The video also corroborated Jane's testimony that the defendant punished her by forcing her to eat feces and spread it on her body. Because the recordings served these legitimate purposes, they were appropriately admitted. The video recordings were awful, but the crimes charged were awful, involving 1, sexual exploitation of minors, 2, forced labor to the defendant's violent, degrading assaults on Geronda to force her to perform oral sex on him, and the defendant's threats, including the presence of a gun, to force Faith into oral sex. 3, kidnapping, and 4, aggravated criminal sexual abuse. Therefore, the court's decision to admit the foregoing video recordings does not warrant a new trial. Now, finally, the defendant faults trial counsel for challenging the videos belatedly. And she mentions that in 276, document 276-1 at 11. As explained above, the evidence was admissible, so counsel could not have been ineffective, even if making a belated objection constituted ineffective assistance of counsel. In any event, counsel moved in limine to exclude the evidence involving Alex and Dominique as highly inflammatory, needlessly cumulative, and because the probative value, if any, of the material is outweighed by the danger of unfair prejudice to the defendant. Document number 203 speaks about this. The defense initially objected to the admission of the government's Exhibit 329A and objected to playing government's Exhibit 328A and successfully challenged the admissibility of another video of joy. In sum, the court's evidentiary rulings were appropriate exercises of discretion. Okay? Now, for these reasons, the defendant's motion for a judgment of acquittal and for a new trial are denied. So that was her decision on Bonjean's motions for a new trial and for the acquittal. So that's what we just read. All right. And that is part of documentation proving, her arguments, showing what she's arguing about. So these are the discussions that she's going to go through with the judges. She's going to talk about the restitution as well.
Come in.
Yeah, so now they're talking about the restitution parts. The herpes medical expenses, all that. That has to do with the restitution. Okay. That is the judgment. Okay. Imprisonments. All right, the supervised release, the mandatory. Okay. So this was just that. All right. And I think this is it. Okay. All right. All righty, guys.
I'm trying to look.
Okay. Okay, so she had to fix the paging as well.
You no way.
All right, that's what that was.
No way. I shot him on the right, then I turned around and shot him in his face.
Okay.
Look at this.
That was that, right?
Yeah, a little bit of energy. How the fuck, bro?
Okay.
Yo, this game is fucking ass.
All right.
Yo.
Yeah, honey.
Fucking 6 o'clock. What time you plan on cooking?
All right, I'm getting off now. Okay.
But I was gonna cook again.
All right, guys. So we are done here. We are definitely done here.
Lady, we need food. I'm hungry.
Shut up.
Be fired and I'm gonna trade.
Relax. Calm down. Listen, your son just ate. Your daughter just ate. They're good.
I'm fucking starving.
There's some chicken pieces over there. You could go have it.
I'm treated like a stepchild here. I quit.
Okay, guys. She submitted all of it, y'all. Okay, so she put in a motion number 62. Let's see what she did here. This is 50 cents for this. Okay. Okay. So she put in today document number 62 that she wants to leave to file an oversized opening brief consisting of 25,000 words. So the appellant is seeking an unopposed motion to file an oversized brief consisting of 25,000 words. Okay. Okay, so the government is not going to respond. Is oral argument on motion requested? No. Has argument date of appeal been set? No. Okay. Now, this is a declaration of Jennifer Bonjean in support of appellant Robert Kelly's unopposed motion to file an oversized opening brief consisting of 25,000 words. So Jennifer Bonjean, of full age and having been duly sworn according to law, hereby declares the following: that I am an attorney licensed to practice in law in the state of New York, the United States District Court of the Eastern District of New York, and the United States Court of Appeals for the Second Circuit. I am the owner and founder of the Bonjean Law Group, which is predominantly based in New York, with a satellite office in Illinois. I submit this declaration in support of appellate's motion to file an oversized opening brief consisting of 25,000 words, pursuant to local circuit rule 27. On March 12th of 2020, defendant Kelly was charged in third superseding indictment with racketeering and violation. Okay, Okay. Okay, the trial itself was lengthy, consisting of 50 witnesses, some of whom were on the stand for days, and the record consists of over 6,000 pages of transcripts and thousands of pages of documents contained within the government's exhibits. There was significant pre- and post-trial motion practices. Okay. The district court issued numerous orders, 180 pages worth, that are challenged in defendant's appeal. Okay, in good faith, defendant believed that 19,000 words would be adequate. It is not. Defendant has raised 10 separate claims, 2 of which deal with constitutionality of statutes and others that are incredible fact intensive, such as the district court's admission of excessive bad acts and challenges the voir dire. Critically, the district court issued a 103-page decision denying defendant's post-trial motions. Defendant serving 30-year sentence, giving the uniqueness of this case. The government has no objection to Mr. Kelly's oversized motion request. For the reasons set forth above, undersigned counsel seeks an order granting Mr. Kelly's motion to file an oversized brief in the amount of 25,000 words. Pursuant to the 28 U.S.C. 1746, I declare under penalty of perjury that the foregoing is true and correct. All right. So she entered that. Now I got to go back.
Yeah, I do. Yeah, I want to push to the right a little bit. There's money over here.
Man.
Just picked up some money.
Hold on, y'all. Okay.
Coming back.
All right, so that was 62. 63s.
Not what I wanted, but hey, let's go. I gotta fix.
Okay, so she redid the appendixes. What is this one? This one's 40 cents. This charge. No, okay, so she also put in a motion to leave to file defendant's opening brief 1 day out of time. So the appellant, Robert Kelly, is seeking leave to file his opening brief 1 day out of time due to extraordinary circumstances. So, has movement notified opposing counsel? Yes. Opposing counsel position on motion? She said, don't know. Does opposing counsel intend to file a response? She said she don't know. Okay. So her declaration, Kelly's motion for leave to file defendant's opening brief. I submit this declaration in support of appellant's motion for an extension of time to file his opening brief pursuant to local circuit rule 27 and federal rule of appellate procedure 26. On December 7, 2022, the district court entered an amended judgment in this case. Mr. Kelly's opening brief was originally due on March 8th of 2023. On February 22nd, 2023, counsel for Mr. Kelly sought a 30-day extension of time to file his opening brief, which was granted. Mr. Kelly sought an additional 1-week extension to file his opening brief in April 3rd of 2023 because of unforeseen circumstances related to Mr. Kelly's own hospitalization, which prevented undersigned counsel from consulting with him. This court granted the extension, and the filing deadline was set for April 14th. Due to the death of undersigned counsel's father on April 13th, 2023, undersigned counsel sought an extension of time until April 17th, in which to file defendant's opening brief, which was allowed. Now, as a result of undersigned counsel's responsibilities related to the passing of her father in Florida, which includes tending to an ailing mother and handling numerous legal matters and death arrangements this weekend, in conjunction with the difficulties of working remotely without access to defendant's office and support staff, undersigned was unable to file the brief yesterday as anticipated. Just by way of example, undersigned counsel had spotty and limited access to Wi-Fi, no printer, and was challenged in her ability to communicate with her colleagues who was preparing the appendix, because the brief must cite to the appendix. It was extraordinarily challenging to complete final citations and comply with court rules, given the lack of infrastructure and working entirely off a laptop, while also managing highly stressful family matters. In light of these extraordinary and unforeseen circumstances, defendant respectfully seeks leave to file the brief 1 day out of time. So defendant is entitled to effective assistance of counsel on direct appeal, and he should not bear any consequences of the poor timing of the death of his attorney's father. Undersigned counsel has been working around the clock to complete the filing of this brief while tending to highly personal and distressful circumstances related to the passing of her father. I declare under the penalty of perjury that the foregoing is true and correct. Okay, so she asked for an extension of the extra day, because of the circumstances that she's involved with her family member being passed. So thank you, Nexi. Thank you, Nexi. Thank you, guys, for those who have donated the super chat today. Love y'all. So now we're going to end it there. I'm going to later on double check back to see what's going on with this. Okay. And guys, do me a favor, please. Thank you.
See that? I shot dead on, bro. This is what I'm telling you.
If you guys would like to donate, you already know my Cash App, Diva Divine Light. For those who are watching the replay, you want to donate to the channel, you can. My Cash App is $ Diva Divine Light. You can PayPal me at Diva Divine Light as well, or you can even Zelle 347-664-9253.
And I take 15%.
All right, and David takes 15% of whatever you Zelle.
It's my 15%.
David takes 15% of whatever y'all Zelle me. Oh my God.
Gotta send extra.
Guys, don't forget, please, before you leave me, please hit that like button. For those who are not subscribed to the channel, please subscribe to the channel, guys. Thank you. Make sure you hit that notification bell. Make sure you put it on all so you can get notified every single time I go live or I upload a video. All right. And please, for those that are on the replay, leave your comments in the comment section below in the video. Let me know what you think about Bonjean and what she's complaining about. All right. And how she's going to do this. I love you guys. Peace.